remedy for that crime is not the forfeiture or the seizure of my property. The remedy for that crime is a fine and imprisonment, but it's not the theft of my property. And furthermore, if there were going to be a seizure of the property as being contraband or used in the commission of a crime or something, it would be seized, and then it would, by judicial process under Title 37, it would then be taken by the state for the state's purposes. It would not be taken by the officer and then given to two towing companies who are two private mercantile interests. And that's an issue of law. So here's what I'm going to do. Remember, I've often said that there are no absolutes in law. I can't sit here and say, okay, in this case it's a trover, here's the way it goes, 1, 2, 3, 4, 5. That's like telling you that on a chessboard, here's the way you always play your side of the chess game. Now, tit-tat-toe is always played the same way, and I can always predict the outcome after the second move. But in chess and in law, we can't do that. So here's what I thought. On Monday, I'll bring this up to our executive board, and I'll say, fellows, what do you think if I were to file a motion with the court and say there are no issues of fact in the transcript that the trial court need consider? Only issues of law. And the affidavits of the defendants and the affidavits of the plaintiff clearly show that the property was George Gordon, that the property was being driven without a driver's license, registration, or proof of insurance, that the police officer seized the property and turned it over to two private companies. And that's an unlawful conversion. There is no statutory authority for it, and therefore, as a matter of law, the court must reverse the jury's verdict. Now, that's a stratagem. I'm sitting here, and here's my chess men out here on the table, and I just went to court yesterday. The judge says, I'll take that under advisement, and now I want to close the sale. I want to take away from that judge. There's an opportunity here. There's his queen sitting out in the middle of the board, and I'm saying, do I want to sacrifice a rook to get his queen? Because when I take his queen, I'm going to lose my rook. Do I want to do that? Well, before I do that, I'm going to go back and talk to my counselors because of my conviction that there's safety in a multitude of counsel. And if my counselors say, but wait a minute, George, once you've made that stipulation, you can never go back and claim that you need the transcript in case this court were to rule against you. That way, when I get to the state Supreme Court, I would have to always, from that point on, as the old saying goes, you know, when a girl left home, they used to say, you made your bed, sweetheart, now go sleep in it. Remember that old cliche? And that's the way this is here. Now, I can demand the transcript so that when it goes to the state Supreme Court, they'll have the transcript to go by, and I'm convinced that that would be better for me. But wait a minute, I have an opportunity here. And if I read the tea leaves correctly, and if I'm convinced, in which I think I am, and I'll review this file over the weekend, and I'll say, wait a minute, there are no issues of law that are in that transcript. If I can determine that that transcript is not necessary and imperative to me, in other words, I'm sitting here saying, I don't need that rook to win. He needs his queen to win. If I can take his queen at this stage of the game, I might be able to snatch victory right at the district court level before I move it on up the line. And after all, I'm interested in victory just as rapidly as I can achieve it. Now, I'm at that crossroads at this moment in time. 21 days from now, the judge will issue an opinion. Probably the opinion will be against me, which will give me my opportunity to move my issue of pauper status up to the state Supreme Court. But what if I were to snatch right out from under the judge the rug that he's standing on and say, now what are you going to do, Judge? There's only issues of law here, and as a matter of law, you have to rule this way because there is no statutory authority for a policeman to hold curbstone court. And he knows that. Now, that judge could use the transcript fee as his crutch. He could say, well, if you don't pay the transcript fees, I'm not going to listen to it. And that's Pontius Pilate washing his hands. Well, I'm not going to kill you, Mr. Gordon, but I'm going to throw you over here to somebody else and let them kill you. And I'm just of the mood to say, I'm going to make you make a decision. So that's why I'm inclined at this moment in time to suggest to you that you consider the same thing. Notice what I did in the scenario. I motioned up a hearing concerning the transcript fees. Ordinarily, we wouldn't do that, and it would die in the district court, because if you don't pay the transcript fees and it dies, I won't get my car or motorcycle back, but I won't pay the transcript fees, and I won't pay the $6,800 and now $7,000 in attorney's fees. But I'd have to log a loss, wouldn't I, because they got away with my car and motorcycle. So I'm sitting here saying, how can I keep this ball game alive? You know, it's the last of the ninth, and we got 2 outs here and 2 men on base, and I'm a run behind. Now, how can I keep this ball game alive? I need a hit. And at this juncture, here's a strategic move for me to make. I'm not going to let it die in the district court. I'm going to keep it alive. And if I'm successful and I can keep it alive, I've got beyond this hurdle. If I can get this batter walked, now I can get my home run hitter up. All right, so now let's suppose that we move on to the next step. And let's take this Trover as an example, and the judge rules against me as a matter of law. I've lost the transcript now. If there was something in that transcript I needed, it's probably gone forever. Although a higher court could decide, you know, we want to listen to the transcript. And they could always come back and order it, but I would never be able, as a matter of right, to compel the transcript to move it up to be heard. And so, you know, I've lost something, but what if the Supreme Court of the United States a year from now gets this case and they say, gosh, this is interesting, I wonder what the transcript says. What they do is they just send a letter down here to Ada County, Idaho, and say, prepare us a transcript and don't give us any guff. Then the state will have to perform and give that transcript to the Supreme Court of the United States. Meanwhile, I have an opportunity at a quick victory here. If I don't make my quick victory here, look at the good faith argument I've made. Gosh, I have nothing but the best interests of the state involved. I'm trying to save you people $1,300. I just want my car and my motorcycle back because we've already lost the malice issue against the policeman. That's going to have to be brought in a civil rights action under Title 42 in the district court. So, I've got the best of both worlds. One, I'm going to get the policeman on Title 42 in the district court, and while the Trover issue is a separate issue at this moment in time, I've actually got 2 shots at the officer that committed the wrongdoing. The first shot was with the Trover, the second shot is with the Title 42 suit. You begin to see how important the appeals are and how costly it becomes now for your opponents. Another thing to keep in mind is that every one of these motion hearings that you bring up, now this is a collateral matter, but I brought up a motion hearing to listen to oral argument to the judge yesterday. That cost them 3 hours. Now if I file another motion and bring them in for another 3 hours, that would be 6 hours, and I'm saying an hour and a half for the argument, and there's 2 lawyers, so that's 6 man-hours. And then the judge can tell me yay or nay, can't he? And in the meantime, we've run the bill up another $400, haven't we? And I'll tell you something else, friends, that I noticed yesterday. When we came out of the courtroom, the 2 opposing lawyers were in heavy conversation outside the door. And I suspect that they were deciding, what are we going to do with this fellow? So far, we're in $7,000. All we've got for it is a 1965 Chevrolet automobile, a 1972 Honda motorcycle. They're probably saying to themselves there wasn't $500 worth of value in both items. And this guy keeps hauling us into court and can keep this up for the next 2 or 3 years until he worms this thing up to Washington. And it could well be that he'll win on appeal because he's got his rights issues set. From my vantage point, I have absolutely nothing to lose at this point in the proceedings. They have a lot more to lose because I'm continually challenging them. It costs about $60,000 to hire a good high-powered lawyer to argue a case to the Supreme Court of the United States. Now, so far I've qualified my case up to the first stage of appeal. All right? I want to see how much money it's going to cost these fellows to get through the first stage, and then the second stage, which is my state Supreme Court, and then the San Francisco, well, see, after the state Supreme Court, I would go directly to the federal Supreme Court. What if, just think about it for a moment, if you were my opponent, and just what if, you were sitting there saying to yourself, what if Gordon were to get that thing calendared and docketed on the Supreme Court's calendar as a rights issue, pursuant to taking that car? You know, you can't argue that case before the Supreme Court. You've got to go to Washington and hire a lawyer who is qualified to practice before the Supreme Court of the United States. And I don't think you'd get one of those guys for less than $200 or $300 an hour. Now, can you imagine? Here you've got a 1965 Chevrolet automobile, and you're going to pay some guy $200 or $300 an hour over some nut that accidentally got a case docketed with the federal Supreme Court. Don't you think you'd want to sue for peace sometime before Washington? You remember that story about the unjust judge, and this widow kept coming to him and pestering him, and finally he said, though I fear not man, nor do I fear God, but because of your continual harassment of me, I'm going to give it whatever it is you want. Now sit down there, lady, and tell me what it is, and then get the hell out of here. Now, do you see the principle involved there? If it works there, it'll work here. Now, it isn't impossible to get a case docketed with the Supreme Court, but there are rules that go with it. Let's go back for a moment at the historical viewpoint of this thing of trying to weed people out and see where it started. Now, I contend, and I have contended for a long time, and I think that I can show, and have shown, that the Ten Commandments are really the heart and core and the basic rudiments of our common law. Well, it just so happened that out there on that Ten Commandments site at Mount Sinai, all these people kept coming to Moses, and they kept saying, oh, Moses, I've got a problem. Harry the tent maker over here put his tent up, and he put his tent peg over here on my piece of ground. My kid tripped on it and broke his leg, and by golly, I think old Harry the tent maker owes me damages for my kid's broken leg. And so this went on and on and on, and pretty soon poor old Moses, you know, he didn't have any time to play golf anymore, and so his whole day now is tied up in deciding these Mickey Mouse issues of who's got whose tent peg on whose ground, and what kind of tort damages are being caused by one fellow over another. And you got 3.5 million people out here, and you know, out of 3.5 million people, you got a few people every day that are getting hurt, you know, having some kind of damages or claims. So Moses was all bogged down. Pretty soon his father-in-law came to him and he said, hey Moses, let me give you this keen idea I came up with last night. Why don't we appoint judges? Why don't we have a judge over 10 people? And then why don't we have a judge over 10 judges and then a judge over, let's say, 100 judges, and let them decide all of these Mickey Mouse issues way down here at the bottom. And as they decide these issues down here at the bottom, probably one of those judges, given a little power and authority, could adjudicate that issue, and you'd have more time for golf and playing and doing the things that you really want to do in life. Moses thought that was a pretty keen idea, and I believe that that's the beginning. What we saw there in Scripture, in the case of Moses, was the beginning of the appellate process. Because we noticed that after Moses died, they went into a system of judges. And remember, under the system of judges, they had a decentralized government that never again was duplicated, so far as I can tell, in all of history between about 1400 BC, about 1400 BC, and 1783 under our Articles of Confederation here on the North American continent. Remember that America is something different in that every citizen is a sovereign. Every one of those Israelites that walked into that particular piece of real estate called the Promised Land was a sovereign. He was a sovereign because there was no king in Israel in those days. There were judges. Now, if you had that system there and you had that appellate process, there's the foundation in the beginning of the appellate process. Now, obviously, the issue is, let's get this thing settled in Idaho. And here's where you have another rule that you must always adhere to, and don't forget this. You must exhaust every remedy available to you within the borders of your state before you can take it to the Supreme Court of the United States. They will not listen to issues until you've exhausted all of your remedies. So don't jump the gun and try to take it 2 steps at a time. It's got to go A, B, C, D. It cannot go A, D, F, because they will not listen to it. All right. So the appellate process then, in this particular case called the Trover, if you'll keep it in mind now, it's a chess game. And each and every move you make has to be made based upon reason, logic, and common sense. And the reason, logic, and common sense is based upon the rules of the game. Remember, your adversary is sitting over here quoting statutes and rules, and they did this to me yesterday. They were going back and forth on the rules, and they're just moving around, and I stuck to my central theme that where rights are involved, there can be no rulemaking or legislation that would abrogate them. And the doctrine of Marbury versus Madison and Miranda versus Arizona, Your Honor, supersede all of the rules and the rules of procedure and all of the statutes of Idaho. I either have a property right in those vehicles or I do not, one or the other. And if it's a property right, it is not specious or frivolous. It's a fundamental issue that must be addressed, so says Marbury versus Madison, and this court cannot ignore my fundamental property right. And the judge is going, That judge was saying to himself, what rule did Gordon miss here? And I think at this point now it's time for us to touch upon, before we get into the nuts and bolts now of this appeal process, which is really simply a matter of following these rules. Remember these 7 rules that you got in Lesson 13. Now let's pull these out, and I'm going to show you what this judge is saying to himself as he's listening to your oral argument and as he's looking at your paper. He's looking at Ashwander versus Tennessee Valley Authority at 297 U.S. 288, isn't it? Remember that the court has frequently called attention to the great gravity and delicacy of its function in passing upon the validity of an act of Congress, and has restricted exercise of this function by rigid insistence that the jurisdiction of federal courts is limited to actual cases and controversies. You have to have an actual case and controversy. Not only does this apply to the Supreme Court of the United States, but every court from the Supreme Court down has adopted these same rules or is certainly familiar with these rules, and that judge is sitting there saying to himself, how can I get out of this? There is no case here. But wait a minute. This guy Gordon jumps up and says, Marbury versus Madison says this is a property issue. It's a rights issue. Now, what if I'd have gone into court and said, well, they took my car and I contend my car is worth $500 and I want them to pay me $500. Now what you're talking about is an amount of money that's in dispute. And no court is going to sit here and listen to the amount of money that's in dispute. My contention is I'm entitled to my car back, period, and I want it back. That's my property, and I want my property back. And that's a rights issue. That's where so many of these tax protesters go astray. They file a Fifth Amendment tax return, and then the Fifth Amendment tax return is signed at the bottom, and it says, I am a taxpayer. What I'm protesting is the amount of tax I owe. That's not a rights issue. That's an administrative process issue. No court's going to listen to an appeal on an administrative process issue. That type of appeal process is done in administrative process, not in judicial process. What I do is I don't fill out the form, and I sit here and say, I'm not a taxpayer. I'm not required to fill out that tax form, and it's a rights issue, and the rights are involved here. We're going to argue to Washington and let the Supreme Court decide whether or not I'm a person who's required to file that form. Let's go on. So we're talking about rights. The jurisdiction of federal courts is limited to actual cases and controversies, and that they have no power to give advisory opinions on the ground that it has in recent years ordered the dismissal of several suits challenging the constitutionality of important acts of Congress. All right, so the court simply is saying, we're not going to listen to certain classes of cases. And this is specifically true when there is no case in controversy. The court has developed for its own governance in the cases confessedly within its jurisdiction. Remember now, Marbury versus Madison, read the case. Marbury versus Madison says the court must listen to cases that have rights controversies in it, and that they cannot ignore or in some way cast aside a rights issue. So within its jurisdiction, a series of rules under which it has avoided passing upon a large part of all constitutional questions. You see that? Avoided passing. And so that judge yesterday was just sitting there, how can I avoid Gordon? How can I avoid this issue? And so what's my job? Rights, rights, rights. Property, property, property. Not going to sit here and talk about collateral issues of Article 1, Section 10. No collateral issues of, well, judge, it's not fair and equitable, and, well, judge, blah, blah, blah. Rights, rights, rights. And that is the only thing that an appeal court is going to listen to. You either have rights that have been violated or you do not. Now, there's another thing that I'm going to lose when I go into this court and I say, I'm going to offer to waive the transcript. Procedural errors. Now, here's what happens on procedural errors. As you're going along, the judge makes an error here, an error there, and an error there. During that trial, that judge must have made 20 procedural errors. But on procedural errors, if those procedural errors mount up and an appeals court says, yeah, we think that there are enough foibles in the transcript to warrant a new trial, all I would get is a new trial in front of a new jury, which is probably going to find the same way that the old jury found. So I'm going to give up a tremendous amount. And if this was a criminal case, I probably wouldn't do it. But since it's a civil case, if I waive the transcript and say there are no issues of fact, only issues of law, then the trial court judge, with all of his errors and mistakes, gets off scot-free, doesn't he? We're not going to raise the procedural errors. Like, look at this jury instruction. Judge, you should have let this jury instruction in. And he left it out. I think that an appeals court would look at that transcript and say, yes, he should have put that jury instruction in. We're going to remand this back for a new trial. Okay, what I want is I want a vindication. I'd be willing to give up my car and my motorcycle if I could get a judicial determination that that was wrongfully converted property, because that's a precedent that I would like to use in my county. Well, let's go on to three more rules now, and let's keep those in mind. The court will not pass upon the constitutionality of legislation in a friendly, non-adversary proceeding, declining because to do so or to decide such questions is legitimate only in the last resort, and has a necessity in the determination of real, earnest, and vital controversy between individuals. In this case, I've got a real, earnest, and vital controversy, and I pointed out in oral argument that in this county they're stealing at least 10 cars a week off of the streets that belong to citizens, and that this is an issue that deserves to be listened to, that it needs to be listened to. Now, whether the appeals court rather, is going to listen to that argument, I don't know. But it's a valid argument. And if he's been sitting there saying, I wonder if I want to listen to this for that reason. It's something more than a friendly, non-adversary decision or controversy, because I'm sitting here saying, hey, wait a minute, there's a lot of people in this boat. And it's already a fact that those guys have my property, so therefore this is an actual case in controversy. They've got it and I want it back. By what authority did they take it? The court will not anticipate a question of constitutional law in advance of the necessity of deciding it. Yesterday, the defense attorney said, there's no issue of constitutional rights here. This is simply a specious and frivolous argument. Why, this is done every day, and it's done by statute, and Mr. Gordon never alleged or pleaded any constitutional issues, and gosh, blah, and again, blah, blah, blah. And got up and I said, wait a minute, property. And I pulled out my state constitution, and I said, wait a minute, at Article 1, Section 2, Your Honor, all political power is inherent in the people. Government is instituted for their equal protection and benefit, and they have the right to alter, reform, or abolish it. Article 1, Section 1. And I have the right here, all men are by nature free and equal, and have the right of acquiring, possessing, and protecting property. This is a property rights issue. You see how I keep hammering that? Hammer, hammer, hammer. On that appeals court. Now I've established a record, and I'm going to take that record, and I'm going to move that up to my state Supreme Court. If this guy turns me down, this appeals court at the district court level, what do I do next? Okay? I take it up to the state Supreme Court and I say, look at this. This district court judge down here refused to listen to an actual case in controversy. So I'll have to write up a motion, won't I? A motion for the transcript of the district court, because they're going to claim, well, this is just a specious and frivolous argument. No, it's not. It's a basic basic issue of law, constitutional law. Number 3, the court will not formulate a rule of constitutional law any broader than is required by the precise facts to which it is to be applied. Okay, and I want you to keep this in mind. Now, while my adversaries are saying Gordon doesn't have a driver's license, registration, and proof of insurance, I was careful yesterday to set that aside. That's a collateral matter, Judge. It doesn't make any difference whether I've got a driver's license or not. The jury found me guilty of not having a driver's license, but that never was the issue before the court. The issue before the court is trover, and it's the wrongful conversion of my property. See how you must stay right to the actual formulate a rule of constitutional law any broader than is required by the precise facts. All right? Judge, there's only one thing for you to decide. Either I have a right to property or I don't. Now, which is it? The precise facts involved here are, they took my property and I want it back. My adversaries are all over the landscape out here. Well, he doesn't have a driver's license. And oh gosh, he didn't have insurance on the car. So what? You see, we want to formulate the rule here no broader than the precise facts require. That's collateral matter. You know, most patriots would walk into that court and start screaming, Article 1, Section 10, I want that car bought and paid for in gold and silver. Baloney. Article 1, Section 10 is a collateral matter. The statutes are a collateral matter. The rules of procedure are a collateral matter. You've got to stay exactly on point. Now, I'm either on point or I'm off point. And boy, I better be on point on this issue. They took my car. I've got a right to the car because it's property. And if I've got a right to that property, that's a narrow issue. And it's an absolute right. And that's my vehicle to Washington, and I can't ever get off of that horse. In other words, I can't argue that over here to the district court and then file a motion for a review in the state Supreme Court and then start talking about money and start talking about reparations and other collateral matters. It's a property rights issue. It's a wrongful conversion, and wrongful conversion is a trover, and there's the central core. That's the nut. That's the meat that's in that nutshell. Number 4, the court will not pass upon a constitutional question, although properly presented by the record, if there is also present some other ground upon which the case may be disposed of. Now, here's another reason for me to offer to dispose of the record. Let's see if my adversaries will say, and I'm going to see if I can put them into this position. I'm almost of the opinion that the record isn't necessary, that the file, that is the case itself, has enough affidavits and legal arguments in it to produce my issue and my argument and to carry me to Washington. Now, I think that's true. Let's suppose I say there are no factual issues to be decided from the transcript, and my opponents say, my gosh, yeah, you can't take this issue without the transcript. Then my argument's going to be, well, gosh, fellas, if you need the transcript, why don't you buy it? You see the way I'm going to move my chessmen across the board? You see, there are some other advantages. Not only do I get his queen for the rook, but it sets me up now to turn around and say, well, now let's see, maybe I can take a knight the next move or two. You see the way you begin to set it up? On the other hand, maybe it isn't a good move. Maybe what we'll do when we talk to the executive board meeting here, what we'll say is, well, no, that's not right, but I'm going to give you some ideas. What I want to do is to show you how to play the game of chess, some of the options that are available to you. That's why it's necessary, in my opinion, that by the time you get a school going in your local area and you get 10 or 15 graduates, and the 10 or 15 graduates have gone into the courts and you've done 4 or 5 cases, now you're in the driver's power position, because now you've got some people that you can talk with, and when you start talking about major cases, this is where these boys are going to start hurting, because this is an insurance company that's arguing this case. And let me tell you, friends, this insurance company doesn't want to pay $7,000 for a 1965 Chevrolet automobile. What they're sitting here saying, worrying about to themselves, is that we don't want Gordon to set precedent down here. We don't want to set him up and give him a blank check for a Title 42 suit. We've got to throttle him down and shut him up, but we've spent $7,000 and the guy won't go away. He just keeps coming back and back and back and back, and it costs us more and more and more money. Now, when I do that, and 5 others of my fellows do that, that insurance company has to start taking notes. And this, at the appeals level, this is where I'm really starting to have fun, because now I'm drawing blood. Up until this particular case, this level, the appeals level, they've raked me over the coals, haven't they? Think about it for a moment. Out there at the scene of the crime, they arrested me, threw me in the back of a police car, and hauled me off to jail and stole my car, and I didn't feel good about that. And I was down, and I was feeling bad. And then they took me to trial, and then they found me guilty, and then they sued to get my property back, and they wouldn't give it back. And now the jury came back, and they gave me an inferiority complex by telling me that I'm wrong. And now that all of that's behind me, now I start to have my day in court. Now it's my turn. Now it's kind of like Rocky. I went through the first 7 rounds, and you just pounded the hell out of me. My golly, now it's my turn to get in a couple of blows. Now I'm going to give you a black eye and a bloody nose. I'm going to cut your lip for a change. And I'm sitting here saying to myself, I've never had so much fun in my life. Those boys have spent $7,000 for a 1965 Chevrolet automobile, and they haven't even got started yet. By the time we get over to our state Supreme Court, I can argue it pro se for myself. It's going to require that they have an attorney who is licensed in that particular court. And no matter what happens at the district court level, whether he says yay or nay for my appeal, I now take it to the state Supreme Court, and I'll file 3 or 4 motions over there. And I'll demand oral argument, and I'll have my opportunity. I'll have my day in court. And if I don't get it there, remember the sword of Damocles is hanging over them now. They're sitting there saying, what if he got that thing docketed with the state Supreme Court? And if not there, let's suppose they can defeat me at the district court, and if they defeat me at the state Supreme Court, and they can defeat me at the federal Supreme Court, from now on, they had to have defeated me 4 times. So far, I only have to win 1 out of 4. They've got to win 4 out of 4. Isn't that right? Do you think that if they were to win the trial level, the district court appeal level, the state Supreme Court level, and lost the Supreme Court level, that they've gained anything? It could cost them anywhere from $20,000 to $60,000, the way I've got it figured, based upon the averages that I see. And they've always got to worry about maybe he'll get lucky at that federal Supreme Court level. Because remember, of the 10,000 cases that go to Washington, 5,000 of them are heard. That means I've got a 50-50 chance of getting that case heard. And if I've done my homework, and if I've followed the rules, and if from the scene of the crime I've carefully documented my position and I've laid it out as the major federal question is a rights issue, I've still got a 50-50 chance, and they've always got to worry, are we going to end up paying $60,000 for that 1965 Chevrolet car? And what if they do buy that one for $60,000? I've got a 1967 Chevrolet car that I'd like to sell them for $60,000. And I'm telling you, friends, it's somewhere between now and the 5th, 10th, or 20th of those 1960 models automobiles, they're going to quit. I think my staying power is greater than theirs. Let's take a look at Rule 5. The court will not pass upon the validity of a statute upon complaint of one who fails to show that he's been injured by its operation. that rule doesn't apply in this case if we're talking about this trover action because it's a civil matter and there's no statute involved. Number 6, the court will not pass upon the constitutionality of a statute at the instance of one who has availed himself of its benefits. Now this is where I'm unique. We've already stipulated that I don't have a driver's license, registration, or proof of insurance, and that I own the property in absolute allodial freehold. There is no GMAC mortgage payments on that car. That car is mine. And I claim that property to the exclusion of everyone else in the universe, including God himself. And that's what the very definition of the word property means. And number 7, when the validity of an act of Congress is drawn into question, and even if serious doubt of constitutionality is raised, it is a cardinal principle that this court will first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. Now they're going to claim that the statutes gave them authority to take that car. And I'm sitting here saying, wait a minute, troops. Statutes and rules and regulations under Miranda do not apply. That where rights are involved, there can be no rulemaking or legislation that would abrogate those rights. And that's the horse that I'm on, and that's the horse that I'm going to ride to Washington on that particular issue. So whether it's civil or criminal, you've got to separate out the narrow issue and qualify that thing right from the scene of the crime to step 1, step 2, step 3, step 4. No matter what happens, you've got your rights issues that are qualified, and each and every one of these issues that you've brought up are issues that could gain you reversal when you go into the appeals process. All right, now let's drop that subject matter here for a moment. We now know what the appeals process is. It's an expensive, long, drawn-out, time-consuming effort on your part to reverse the decision of the trial court. And in the case of a civil matter, if you're judgment-proof, you can only win and you can't lose. That's why, while it's not against the law to be a pauper or poor, it's certainly advantageous if you're going to go into the courtroom. All right, I told you where it started, and that's with Moses. And how to post bond and plead not guilty. All right, we talked about that right off the bat. What you want to do, just to recapitulate now, at the sentencing, you want to make sure now that you either have enough money to post bond to stay out of jail if it's necessary, that you have your stay of execution pending appeal, and that you have your notice of appeal ready to go. And with this lesson, we're going to send you a sample notice of appeal, and we're going to send you the brief in support of that notice of appeal as a sample. That's so that you'll have a guideline to go by. After you've done one, you can do them all. And remember, the appeals process is no huge mystery, that requires 4 years in college to understand. Rule 54 is simple and straightforward. You simply look at it and it's going to say to you, and I'm going to cover that here in the second half of this lesson, it simply says step 1, step 2, step 3, and you're going to do it step 1, step 2, step 3. And if you can write a letter, you can write an appeal. Now, I want to talk to you about this thing of stipulating to the facts here for a moment, because stipulating to the facts reduces the entire process to the issues of law and separates out the issues of fact. Now, it may be that there are issues of fact that you'll want to keep into your case. If you want issues of fact, you need that trial transcript. Issues of fact, as an example, are contracts and deeds and all kinds of paper and evidence and things like this that would show that based upon the statute that your position is correct. You're a corporation, you're in some corporate capacity. As an example, maybe there's a foreclosure on your house. And during this foreclosure, there's a certain amount of facts that need to be adjudicated in front of the jury, and those facts will have to be appealed upon. That's a factual issue. Those are facts that must be brought out in the transcript and moved up through the appeals process. But when you're talking about the driver's license, registration, and proof of insurance, which we call the big three here, there are only issues of law involved here. I either have a right to drive as a matter of law or I do not. And I either have a right to that property or I do not have that right to that property. And so there are no factual issues. I don't have to sit here and say, well, did he have a license or didn't he? Was he validly licensed at the time the car was taken or wasn't he? Who cares? You see, the remedy for the government never was the conversion or the taking or the forfeiture of my property. You understand that issue? So since forfeiture was never a remedy available to the government, I don't care about the facts, whether or not I had a driver's license, registration, and proof of insurance. Now, however, if a person were a taxi driver and he were required to have the license, registration, and proof of insurance, and the officer took his car, then it would be necessary as a factual matter to show from the record, yes, I did have a license, and here's the proof of it. Here's the dates, times, and places. Here's the signature of the Department of Law Enforcement. If he had insurance, yes, here's my insurance agent, and here's his testimony, and yes, the insurance was in full force and effect. You see, if you need those facts, then you would need that factual record to go into the appeals process with. It happens that in this particular case that I've given you the two examples of today, the driver's license, registration, proof of insurance is a criminal matter on the one hand, and I'm going to cover in a moment, and the Trover action, which is a property rights issue, can I have my property back? Those items are merely issues of law. And as issues of law, I'm going to sit here and open up the law book. I'm going to sit here and pull out my Constitution, my state Constitution, and say, this is where it's at, troops. And there are no issues of fact that any of these courts need to take into consideration. So in the two cases that I've shown you now up to this moment in time, when we go forward, we're going to talk about issues of law. We're going to ride that horse of property and this driver's license registration, or this rights to drive on the roads as a matter of right, and we're going to ride that issue to the Supreme Court of the United States. I guess on the next issue we want to take up, let's talk about a demurrer, because that's exactly what a demurrer is. So let's pull one of those out. Take a look at that.